Parks, were you ready on your second call? Going back to 2020 CR 83, State versus Stephen J. Jowell.
Yes, Your Honor, the state's gonna move to nolly this case. It was an old case, and Mr. Dowell flew down here, drove down here from Michigan. He has shown proof that he was his life for the voters. It's an older case, so since he's
Where's he live now?
Michigan.
this is one we talked to Your Honor about.
So we're banishing him from the realm.
We are, yes.
So we're nollying the case with the hope that he never sets foot in Tennessee again.
Or if he does, it's just spread good for the chair.
All right. Case is dismissed.
Thanks, sir.
Twenty 2024 CR 60, State versus Daniel Franklin Phillips. Clemens.
Yes, Your Honor. We have some video on that one.
All right, I've been handed a document indicating that Mr. Phillips is going to be entering, a plea of guilty to count 1, simple possession of methamphetamine, a Class A misdemeanor. Counts 2, 3, and would be dismissed, as well as 2024 CR 60. He would receive a sentence of 11 months, 29 days, suspended to supervised probation after served 30 days in jail, $750 fine at cost. So waive court costs.
Yes, Your Honor. We'll pay the fine.
Complete an alcohol and drug assessment, follow treatment recommendations. Jail can be served on consecutive weekends beginning September the 5th. Raise your right hand, Mr. Phillips.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God. Sir, thank you.
Turn that microphone towards Mr. Phillips. State your full name for the record.
Daniel Franklin Phillips.
Mr. Phillips, you're here today charged with a multi-count indictment. Actually, 2 different indictments have been indicating you're going to plead guilty to 1 charge, and the rest are all going to be dismissed. But have you seen or been shown a copy of the charges? Talk them over with Mr. Clemens and feel like you understand the charges against you and the range of punishment you're facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand if you went to a trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of a crime. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena. Do you understand that that if you went to trial, you would be presumed to be innocent and you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial? You understand that if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyer has worked out. You understand that's going to result in a misdemeanor conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath and on the record, and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we were to find that you had lied under oath. Is your decision to plead guilty today voluntary? Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied you are, in fact, guilty of these charges and that there are facts to support it. Are you in fact guilty of this simple possession of methamphetamine?
Sir.
That kind of speaks for itself, but you were in possession of an amount of a small amount of methamphetamine.
Sir.
All right. Anything further that you feel like is necessary from the state?
No, Your Honor.
All right. Are you satisfied with your attorney services?
Yes, sir.
I feel like that Mr. Clemens has done a good job of representing you competently.
Sir.
Mr. Clemens, you know of any reason you should not enter this plea?
No, Your Honor.
Then Daniel Phillips, in this case, you were found guilty of simple possession of a methamphetamine and sentenced to 11 months and 29 days in the county jail. That will be suspended to supervised probation after serving 30 days in jail on consecutive weekends beginning September the 5th, 2025. You ordered to pay a $750 fine. You were also, as a condition of your probation, ordered to complete an alcohol and drug assessment, follow all treatment recommendations. Counts 2 and 3 of this indictment are dismissed along with 2024 CR 60. He needs to see the probation officer before he leaves.
Yes, Your Honor.
All right, let's talk about that. This hearing in Judge David D. Wolfe's courtroom had all the elements of a classic plea proceeding: careful questioning, measured answers, and a clear resolution, but it still gave us a little courtroom color. Along the way, Judge Wolfe carried himself with a steady and professional demeanor throughout, showing the right balance of patience and firmness. He walked Daniel Franklin Phillips through every stage of the plea colloquy, step by step, making sure there was no doubt about what rights were being waived, or what consequences would follow. If you've seen Judge Wolfe before, you'll know this is his hallmark: clear language, no shortcuts, and ensuring the defendant is truly informed before signing on to an agreement. As for Daniel Phillips himself, his responses were short and to the point. Yes, sir, after yes, sir. There wasn't much hesitation, and he didn't appear flustered or confused. He actually came across as cooperative and resigned, almost like a man who knew the weight of the situation and was ready to accept it. There was a telling moment when asked if he was guilty. He gave the kind of answer that implied the facts spoke for themselves. No drama, no excuse-making, just acknowledgement. That tone tends to work in your favor with a judge, and you could see Wolfe take note of the straightforward demeanor. On the attorney's side, defense counsel Mr. Clemens handled his role effectively. He appeared well prepared and had obviously gone over the terms carefully with his client. When the judge asked if he had any reason his client shouldn't enter the plea, Clemens confidently said no, which tells us he was satisfied with the agreement and with how the court was handling the case. The state's attorney also kept things simple and efficient, outlining the deal without fuss or theatrics. Everyone seemed aligned in moving this to a clean resolution, which is exactly what a plea hearing should be. The overall courtroom atmosphere was calm and businesslike, with just a touch of levity sprinkled in at the very beginning, when Judge Wolfe quipped about banishing another defendant from the realm in an earlier case that same day. You could sense the courtroom easing into a more relaxed tone. By the time Phillips' case was called, the humor had passed, and the room shifted back to the more formal rhythm of a plea proceeding. It wasn't tense, chaotic, or combative. If anything, it felt like a steady march toward a resolution that all parties were ready to finalize in the end. Phillips walked out with a suspended sentence of 11 months and 29 days. 30 days to be served on weekends, a fine, and conditions of probation that included an alcohol and drug assessment. It's not light, but it's a manageable outcome compared to what could have happened if things went to trial. And the way Wolfe handled it, you can see why defendants and lawyers alike appreciate his thoroughness. He makes sure the box is checked on every constitutional right, but he never loses the human touch in making sure the person standing before him knows what they're agreeing to. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.